Hello, students. This will be your next to the last lecture on dealing with Chapter 8, the Right to Counsel. Basically, when we look at the right to counsel, the chapter itself really deals not just with the right to counsel, it deals with two basic concepts. The one subject area, of course, is the Sixth Amendment and its specific right to counsel guarantee. And the chapter also deals with the various constitutional restrictions that the Constitution places on pre-trial identifications, which are usually conducted under the control of the government or its agents, the police. Well, we start out on this. Let's look at the first major concept in this chapter, and that deals with the right to counsel provision. Now, the Sixth Amendment basically says, and I think it's important to, starting this off, to realize that this provision about right to counsel starts out with in all prosecutions. It's in all criminal prosecutions, the accused shall enjoy the right, to basically the assistance of counsel for his defense. So, that's a very important language, in all criminal prosecutions, to assist in your defense. The right to counsel provision and why it is in there, the basic policy provision was that to ensure that the trials themselves are conducted in a fair manner, and that innocent individuals will not be convicted in our legal system. Also, that there is the basic idea that an attorney would be necessary to ensure that all the constitutional rights that we have as citizens, and actually as persons, because remember this applies to persons in the United States, that we have as defendants when we're a criminal defendant. The attorney ensures that we have all our rights that we have, that we're aware of them, and that they are presented for us. Okay, when we start looking at the idea of the right to counsel, remember that initially for about the first 150 years since the drafting of the Constitution, basically this idea was always, the idea of right to counsel just meant that the government would not prevent you from using an attorney. The framers never had the concept in mind that this right to counsel was designed to furnish, that you would be furnished an attorney based on your indigency, the inability to hire someone. It was the idea that you would not be stopped from bringing an attorney because it was accepted that you could defend yourself. So that's important to understand that basic idea that we had initially. Later, through judicial interpretations of this amendment, the Supreme Court has grafted a variety of different protections on this basic premise of the right to counsel. And probably if we look at the biggest distinction on the right to counsel in the historical development of it dealt with who exactly should the government furnish counsel for. And when we look at that, initially that concept, as construed by the courts, dealt with people who were basically unable to read, illiterate, or they had various types of disabilities or infirmities that they were unable to participate in a trial, and so the trial itself would not be fair because they could not represent themselves. This changed. And also these provisions by various states who had their own provisions to try to protect this normally involved very serious crimes. The case in your textbook, Gideon versus Wainwright, on the surface of this case, it's not so exceptional in that it was an exceptional case in how that the Supreme Court applied federal law the way they'd already applied federal law to the right to counsel provision, in that all criminal defendants who were faced with, charged with crimes in which they could receive a sentence of confinement, and they were indigent, they would be furnished with counsel, that was now applied to state governments. And to do that, the Supreme Court in Gideon had to move beyond the 14th and 5th Amendment concepts of due process that were previously applied in looking at these right to counsel cases, because the idea was that only with the trial would be so fundamentally unfair that it violated due process would the counsel issue become of a constitutional nature. In Gideon, what we have is the Supreme Court taking the right to counsel provision under the 6th Amendment, which they had previously applied in federal cases, in the federal system, and they took that 6th Amendment right and applied it to the state governments through the 14th Amendment vehicle. They incorporated that into the 14th Amendment. And now we had the idea that just the right to counsel itself for the original policies, that you would have a fairer trial, that the attorney would assist, would be able to assist any indigent defendant, because under a due process sole provision, that's the only provision they'd have had, it's unlikely that the Gideon decision would have been decided the way it was, because Gideon was a very bright individual and was fully capable of actually conducting himself well at trial. So the court used the 6th Amendment concept alone. Just the right to counsel itself was so important to the states that now the right to counsel was considered a constitutional requirement for cases involving an indigent defendant who was charged with a felony in the court system. So Gideon, we now have this right to counsel concept, which the court later narrowed somewhat, in which so the current status of the law is that basically if you're indigent, and the indigency is a question that's decided upon by various states and by the federal government. They have provisions to determine whether you're indigent enough that you are not required to come up with your own counsel, that the government will furnish one for you. If you're facing if you're facing a charge that involves imprisonment, then you're going to be furnished with counsel. That means that if you have a misdemeanor charge, for example, in which the only penalty is going to be a fine, then you do not have the right to counsel. So you can be, if you're going to be fined for what you did, then there is no right to counsel. But if you are going to be possibly incarcerated, then the right to counsel springs into being. So that's where we're at the current status in regard to the right to counsel decision. The second area involving right to counsel is also another concept that the court developed apart from just looking at the amendment itself, the 6th Amendment itself. The court decided to apply the fact that you would need to have counsel present at a variety of basically proceedings, or what, as the court interpreted as certain critical stages of a prosecution. Critical stages of a prosecution, there was a requirement that counsel be there to assist the defendant if the defendant needed counsel there. And when we look at this, the idea comes up as to what is a critical stage. And of course, this is a perfect exam question. What is a critical stage of the prosecutive process in which the right to counsel basically springs up because you're facing that stage of the process. Well, you basically have three requirements. One, the government has to have initiated the prosecution. Initiation of prosecution, we've talked about on other videos. But again, it means essentially when you've appeared before a magistrate or a judge, or the prosecutor has charged you formally through the grand jury process or an information, it is past the investigatory stage. It is now going forward. You are being prosecuted for the crime. You're being formally charged, for the crime that you've been investigated for previously. Basically, when we look at this initiation of prosecution, that's the first thing we have to look at. Is it at the prosecutive stage? Because if it's not, then you don't have that Sixth Amendment right. Now, the best example of this is the lineup. The lineup is a very valuable tool involving eyewitness testimony. If the lineup, if you as a defendant would be arrested for a crime, the police at that particular time have the right to put you into a lineup and have witnesses attempt to identify you during this pre-trial proceeding, and that is without the Sixth Amendment springing into being, and counsel does not have to be afforded you if you're the defendant during the lineup, because prosecution is not initiated normally at the time of an arrest. And because of that, there is no Sixth Amendment right. So the police do have that particular right to put you in a lineup during that type of proceeding. Now, if the initiation of the prosecution has commenced and you're being arrested, or at that point, you have the right to have counsel present to assist you at that time. That doesn't mean the police can't put you in a lineup. They can, but they have to afford counsel. If they refuse to have counsel present there, they don't afford counsel for you if you're indigent, then basically that pretrial identification will end up being unconstitutional. And an unconstitutional prosecution can have repercussions as to testimony at trial, and it also has any type of in-courtroom identification during the trial itself can also be jeopardized by that unconstitutional action of not allowing counsel to be present after a prosecution has been initiated. Now, the third factor, were two other factors on a critical stage. One, there has to be a confrontation element present at that particular point, and that confrontation means between the defendant and the law enforcement officer, the agent of the government, and that confrontation is an important concept that normally you would want to have an attorney there to advise you on how you handle that particular confrontation, and also to obviously serve as a witness to the procedures that are being used. And lastly, the encounter itself, that confrontational encounter, it has to be important enough that your rights that could be jeopardized would actually affect the fairness of the trial. I mean, this has to be an important type of proceeding that if unconstitutional procedures were utilized, it would affect the later fairness at trial. Okay, so what are critical stages? Well, we know the most simple ones, any court appearance. If you're appearing in court, obviously a critical stage, you have the right to counsel. That's bail hearings, preliminary hearings, arraignments, sentencing. The court has also applied this to your first appeal and any post-sentencing types of hearings. So that's the easy ones. Now, the other ones are the pre-trial investigative encounters. These are the encounters where even though prosecution may have been initiated or not initiated. It's a pretrial investigative procedure where the police are the other present. They are present as the agents of the government and with the defendant in this encounter that they're going to have. The main three encounters that we should focus on that you're going to see in a question that might be on an exam would be the lineup, the show up, in the photo identification, the interrogation itself. Those actually, the show up, the lineup, the photo identification, or the interrogation process itself that takes place before the trial. All of these can involve Sixth Amendment right to counsel, and whether or not they are considered critical in nature. Again, not all of them are. Probably our best example of that is going to be the photo identification, the photo spread, a commonly used investigative technique usually used to narrow down the potential list of suspects. Although that is an encounter, it's not been considered an encounter of such importance that unconstitutional behavior could actually affect a fair trial. And the reason for that is that photo spreads have to be capable of being reproduced. So the proceedings that occur at a photo spread have to be reproduced and are capable of being reproduced at a trial. If they're not, for example, if you can't reproduce how the photo spread was done, then that's going to be a violation of due process. In fact, that's normally how photo spreads are attacked. They are violations of due process. They really, since counsel is not an issue, usually a defendant's attorney will attack how the police conducted the photo spread, and that can be, in some cases, testimony of witnesses to it. In other cases, they'll look at the evidence as to how it was conducted to try to show that it was fundamentally unfair and would basically violate your rights of due process. Okay. Couple peripheral matters on this. The one, we know that this right to counsel, the defendant still has the right to be counsel, to actually to go pro se and conduct his defense by himself. Now, the court, that is a right. The court has to ensure, though, certain proceedings that, in fact, he is capable or she is capable of conducting their own defense, and that that this in effect is not causing the trial to be unfair. Generally, the court uses a variety of procedures to show that they've ensured that the defendant who wants to go pro se is fully capable of doing it. Oh, all right. I'm trying to make sure we hit all my key points here. If you have counsel and counsel is present at a critical stage, what can counsel do? Think about that. Can the counsel interject during a lineup? The courts have held consistently the counsel does not have the right to interject themselves. They can make suggestions because, again, this can be reproduced later. The main factor is having counsel present, but the counsel certainly can't stop the proceedings. Now, that's different for an interrogation. If you want counsel present at the interrogation and the counsel says you're not going to talk anymore, you want the interrogation to be over, then of course the counsel can do that. That particular provision is different in regard to their degree of power that they have. So counsel's present at interrogation, they have a great deal of control. They can interject, they can stop, they can say certain questions shouldn't be asked, but not with your lineups and also not with show-ups. They certainly are witnesses and they can offer suggestions, but they cannot stop the proceedings. Okay. In regard to the due process concept, and again, when we start looking at pretrial identification procedures, especially, we look at the photo spreads, the lineups, the show-ups, due process, even if counsel is present, that the issue that can be attacked on is the due process has been violated. So even if counsel is present, the Sixth Amendment is there, again, on these provisions regarding the show-ups, the lineups, where the counsel cannot really change anything. The attack on the police actions are going to be that due process was violated in the procedures that were being used. Okay, so remember that even if counsel's present, counsel may have suggestions that even though the Sixth Amendment right is there, it cannot be attacked on that point. But we're talking about a pretrial identification. This identification can still be attacked on due process, how it was conducted, the process that was being used. Was unfair, discriminatory, fundamentally flawed, and it was material in nature, that this particular identification. And when we look at this, remember that basically the idea of a pretrial identification also affects the in the courtroom at the trial, that identification, unless there is an exception. Your pretrial identification could violate the Constitution. But if the prosecution is able to show that the identification of a defendant by witnesses, that the witness has sufficient knowledge and the circumstances were such that that identification is based upon information and the circumstances apart from the pretrial identification, then that in the courtroom identification can be considered constitutional in nature and be allowed to be put in. The waivers. The general procedure for the right to counsel is that the police in right to counsel, again at critical stages, they have to advise the defendant that they have the right to an attorney under the Sixth Amendment, and they have to receive a valid waiver. If the defendant goes ahead and starts to engage goes through the procedures that they have to, as part of the process of the procedure itself, like agreeing to cooperate in a lineup after they've been advised of their right not to, then they are waiving their right at that stage. Again, let me ask a quick couple of questions to give you an idea as to what a test would look like on this. For what crimes do indigent defendants have the right to have counsel appointed? Remember what that answer would be. We're talking about crimes that do not involve incarceration. I mean, crimes that involve incarceration. That would include a misdemeanor that has incarceration as the penalty, as one of the penalties. What three requirements are necessary for a pretrial event, some encounter or event, to be considered a critical stage in a criminal prosecution? Again, it's important. We know that there are three basic things you have to look for. One is that has a prosecution been initiated? Two, is the encounter adversarial? And three, are there important rights at stake such that the absence of the attorney, and if those rights are violated, would cause the fairness of the trial to be put at risk. So remember, you have those three basic conditions, then you know that the lack of having an attorney present will violate the Sixth Amendment and will cause any pretrial identification to be unconstitutional, which can jeopardize the additional identification at trial. Okay, that winds it up. Thank you.